Hello, my name is Stephen Hunter. I'm a partner at Quarles and Brady in Chicago in the commercial litigation group. I'm also an certified electronic discovery specialist.
My name is Jonathan Sherman. I'm a principal here at Shelist in Chicago, and I practice in the litigation group.
Hi, I'm Matt Prewitt. I'm with the law firm of Schiff, Hardin in our Chicago office in our general litigation practice, and I'm also a member of the firm's e-discovery committee.
The court was asking KPMG basically to hold thousands of hard drives of its former employees.
Pippins is an interesting case because it's gotten attention as an e-discovery case, but at the end of the day, I think it really is a case about the lessons that we're supposed to learn as litigation counsel at the beginning of our practice, which is really all about cooperation.
KPMG kind of took a hard-line, traditional litigation type approach, and they said they're not doing it.
So the trial court in this case did exactly what trial courts have been doing since we've had discovery in the federal courts, which is the attorney who behaves in the manner that is perceived as unfair or heavy-handed gets spanked.
Before a lawyer can effectively meet and enter into agreements with his or her opposing counsel, he or she has to be very clear and very certain as to what the client wants and what the client needs.
I think that in my experience, the knee-jerk reaction is to resist everything that opposing counsel would like to do. You don't want to disclose to them any information that you think might give them an advantage in the litigation. And the courts now, as well as the legislature, depending on where you are in New York, the legislature has pretty much demanded that the parties cooperate, or the judiciary has demanded that the parties cooperate in kind of a pretrial discussion and that it actually be substantive. Ask opposing counsel to have a substantive meeting about specifically electronic discovery-related issues.
Empathy is always a good approach, understanding that each side has a professional obligation to work zealously on behalf of his or her client.
You should have a checklist of those things that you want to accomplish in your meet and confer, so that you make sure that you get all of the things checked off that you'll need from the other side.
Even though a judge may not say that certain costs are recoverable under the statute that applies to a particular dispute, usually a judge will defer to an agreement between the lawyers if they have agreed on a resolution as to how costs should be allocated.
Some courts, especially in Texas, are actually suggesting that the parties depose one another's IT sources so you can get a good idea of where the data is. So
it's also important that if the lawyers for a case are not able to reach agreement, every lawyer should go into court as early as possible and seek a protective order. A judge will look very favorably on a lawyer who has tried to resolve disputes, and if he or she is unable to resolve a dispute, comes early in the case to the judge to seek clarification.